Carelessly causing harm, Part 1. In this video we will explore the legal consequences of carelessly causing harm to another person. Even if the person who has caused the harm did not deliberately cause the harm, they may still be liable to the person who they have harmed if they have been negligent. The tort of negligence is by far the most common tort. Most acts that cause harm to other people are the result of carelessness rather than intent. Most car accidents, for example, are the result of careless driving, not a deliberate effort by one person to cause harm to another person. The law of negligence is traditionally case law, but since the insurance crisis in the early years of the 21st century, the law of negligence in Australia has become a combination of case law and statutory rules. Most of the basic principles of the law of negligence are found in cases, but there are statutory provisions in the various state civil liability acts that modify the case law. There are three requirements that have to be established in order to prove that the tort of negligence has been committed. First of all, it must be shown that the defendant owed the plaintiff a duty of care, in other words, that they had a legal responsibility to be careful. Secondly, that the defendant breached their duty of care by, in fact, being careless. And thirdly, that the breach of duty caused the plaintiff to suffer reasonably foreseeable harm. What we'll do is go through each of these three requirements. So the first requirement is a duty of care. In order to sue the defendant in the tort of negligence, the plaintiff has to show that the defendant owed the plaintiff a duty of care. Now, in most cases, in most problems, this is going to be relatively straightforward. Courts have been deciding negligence cases for many years, and there is a long list of precedents that establish the existence of a duty of care in particular circumstances. So if you are trying to solve a particular legal problem, either one in tutorials or on an exam, or one in your own business or personal lives, then the first step is relatively straightforward if you can show that the relationship is one that falls within one of the established categories of duty of care. So, for example, it is well established that a manufacturer owes a duty of care to a person who uses their product. It is well established that a motorist owes a duty of care to other people on the road, other drivers, pedestrians, and people in the vehicle with the motorist. It is well established that doctors owe a duty of care to their patients, just as lawyers owe a duty of care to their clients. And it is well established that employers owe a duty of care to their employees. So an employer has a legal obligation to ensure that the employee's workplace is a safe one. If, however, you are confronted with a problem and you cannot find a precedent that establishes the existence of a duty of care, then you are going to have to go back to first principles. So if the relationship does not fall within one of the established categories, the plaintiff must establish that two tests are satisfied. First, it must be shown that at the time of the incident it was reasonably foreseeable that the defendant's conduct could cause harm to someone in the plaintiff's position. So this is the reasonable foreseeability test. In order to establish the existence of a duty of care, it has to be shown that at the time the defendant was doing whatever it was that they were doing, it was reasonably foreseeable that what they were doing could cause harm to someone in the plaintiff's position. The classic case that illustrates this, in fact, the case that established this as a precedent, is the case of Donoghue and Stevenson from 1932. The facts in that case were that Mrs. Donoghue was injured. She became sick when she drank from a bottle of ginger beer that contained the decomposed remains of a snail. Mr. Stevenson was the manufacturer of the ginger beer, and Mrs. Donoghue commenced legal proceedings against Mr. Stevenson seeking compensation. The legal issue was whether or not Mr. Stevenson had a legal obligation towards Mrs. Donoghue in the absence of a contract between them. The decision of the court was that Mr. Stevenson did owe a legal obligation to Mrs. Donoghue, and in making that decision, the court established a principle that went on to become the foundation of the law of negligence. The court explained, that rule that you are to love your neighbour becomes in law, you must not injure your neighbour, and the lawyer's question, who is my neighbour, receives a restricted reply. You must take reasonable care to avoid acts or omissions which you can reasonably foresee would be likely to injure your neighbour. Who in law is my neighbour? The answer seems to be persons who are so closely and directly affected by my act that I ought reasonably to have them in contemplation as being so affected when I am directing my mind to the acts or omissions which are called in question. What the court is essentially saying here is that whatever you are doing, you owe a duty of care to those people you can reasonably foresee as likely to be affected by your actions. If you are driving your car, it's reasonably foreseeable that the way you drive could have an effect upon the people in the car with you, so you owe them a duty of care. Your conduct could affect other motorists on the road, so you owe them a duty of care. And your conduct could affect pedestrians on the side of the road, so you owe them a duty of care. In Borhill and Young from 1943, the relevant facts were that the plaintiff was shocked when she saw the defendant lying in the road after having been involved in a motorcycle accident. The plaintiff was not actually involved in the accident herself. She didn't witness the accident, but she did see the defendant after the accident. The plaintiff commenced legal proceedings against the defendant seeking compensation for the medical costs associated with the shock of seeing the defendant in the state that he was in. The question for the court was whether or not the defendant, the person who was riding the motorcycle and who was involved in the accident, owed the plaintiff a duty of care. Does someone on the road owe a duty of care to someone who is not on the road, who is nowhere near the road, but may see the consequences of an accident at a later stage? The court decided that it was not reasonably foreseeable that the way the defendant was riding his motorcycle could cause harm to someone in the plaintiff's position. So the defendant did not owe a duty of care to the plaintiff, and the plaintiff was not entitled to compensation. The second requirement, if we are going back to first principles, is that the plaintiff must show that the salient features of the case are consistent with the existence of a duty of care. What happens here is that the court essentially looks at all the relevant characteristics and features of the case before deciding whether or not to establish a new precedent and recognize a new category of duty of care. The court will consider the relationship between the parties and other features of the case, and then compare those features with the features of other cases where a duty of care has been found to exist. In Sullivan and Moody, the facts were that the father of a child was accused of engaging in child abuse as a result of a report by the doctor of the child to the relevant government department. It later turned out that the father was not guilty of child abuse, and the father sued the doctor in the tort of negligence. The legal question then was whether or not the doctor who was treating the child owed a duty of care not only to the child, but also to the father of the child, to the parents of the child. The court decided that, taking into account the salient features of the case, the doctor did not owe such a duty of care. The court referred, for example, to the fact that if a doctor owed a duty of care both to the patient and the parents of the patient, there could be competing interests in those duties of care, and that a doctor who suspects that a child is being mistreated or abused should not be concerned about the interests of the parent when deciding whether or not to report that case of child abuse. So the court took into account the relevant features and decided that in this case no such duty of care should exist. A doctor of a child does not owe a duty of care to the parents of the child. They only owe a duty of care to the child.